Hello, everyone, and welcome to this month's monthly immigration litigation roundtable hosted by CARE Coalition's Immigration Impact Lab. I'll mention it in a moment. We're actually changing our name soon, so just CARE Coalition for a few more days. And we still got people joining in. I'm admitting as I speak. So thank you all so much for taking the time to be here and learn about this topic with us. As always, in these monthly immigration litigation roundtables, we really want this to be a collaborative space, a space for strategy discussion and idea sharing. So it's very informal. We are providing a training, as always, in the beginning part, just to make sure y'all are getting some value and we can provide some guidance to support you all. But we do want to hear also from your ideas, your experiences. So feel free to come off mute at any time and interrupt us or pop a question or comment in the chat. And if you're listening to the replay, you are welcome to reach out as well to us. The easiest way is lab@carecoalition.org. And I guess now I'll say our new name. We're going to be the Amica Center soon. I'll share more in a moment, but it will be lab@amicacenter.org. And today I'm here with my very brilliant colleagues who will be presented from the Immigration Impact Lab. We have staff attorney Amelia Dagan and senior attorney Peter Alfredson. Both of them regularly do immigration and asylum appeals at the board, at the circuit courts. They're very familiar with this topic. So they have a lot of value to be sharing with us today, and I'm grateful for them preparing this presentation. We also have model briefing that we'll be sharing that they have created. So a little bit about what is the Immigration Impact Lab. And here's the slide where we officially announce our new name to you all, in case you haven't heard yet. As of this Monday, June 10th, we will now be the Amica Center for Immigrant Rights. Short will be Amica Center. We are rebranding and renaming our organization in honor of our 25th anniversary. And picking a name that's a bit more reflective of the work we've been doing that is now not just limited to the capital area anymore. We are in particular providing direct services to people detained and doing impact litigation across the 3rd, 4th, and 11th circuits. And that is part of why we have these roundtables, to bring together other folks who are also working on these issues that we can collaborate with and support. As I mentioned, you can refer cases. The new email will be on Monday, lab@amicacenter.org. We're always happy to take a look at any referrals. We vet every single one and consider them for amicus, co-counseling support, mentorship. Each month, we will continue to have these roundtables. We have them planned out for at least the rest of 2024 on key issues with resources that I email out after. This month, we'll be sharing, as I mentioned, model briefing for overcoming MRMS in family-based asylum and withholding of removal claims for the 3rd, 4th, 5th, and 11th circuits. One question I have for you all before we jump in is just to get a sense of where people are practicing. We have a very short poll that I'll put in the chat that I think it's just 2 or 3 questions for us to ask what circuits you're practicing in so that we can continue to make resources for those circuits where most people are. So please take a moment to fill that out if you haven't already. And I will kick it over to the next slide to Peter and Amelia to get us started. Thanks so much.
Hi, everyone, and thank you so much again for making time today. As Adina said, we will be covering some topics around the December case that came out last December, a matter of MRMS, and we will be walking through kind of the legal backdrop to that case, the specifics of what actually happened in that case and what maybe didn't happen that people misunderstand the case about, and then also some tips and tricks and some research for you guys about where to start in drafting your cases before the IJ and BIA moving forward after this case. But if at any point you have questions, I see there was already one in the chat, we will definitely be talking about that. And so if there are questions you have, please do feel free to let us know. So to get us started today, we are going to talk about sort of the legal backdrop to matter of MRMS, what was happening before this, and what was the context for this new BIA decision. So as a brief refresher, kind of going back to the very basics, the statutory language for family-based claims is found in the refugee definition, where people are able to seek protection if they fear persecution or due to past persecution or having a fear of future persecution on account of the protected grounds found in the statute, including, most relevantly for our conversation today, membership in a particular social group. For a lot of this conversation, we will be kind of using the phraseology of asylum, though the same protected grounds do apply for claims for withholding of removal as well, under INA Section 241. So as a bit of background on BIA case law, there is a pretty large body of BIA case law on family-based particular social groups, PSGs. But some of the ones we chose to highlight today are kind of the seminal cases that show up in most conversations about PSGs. And the first one is Matter of Acosta, which defined a particular social group. And most importantly for Matter of MRMS, it stated that a quintessential example of an immutable characteristic of such a PSG would include kinship ties. And this set the stage for family-based groups to become a norm in asylum and withholding claims. Other cases, for example, are Matter of H, a case in the 90s that also recognized clan groups. That was in the kind of specific context of Somalia, but it was the same idea that family or clan can define a particular social group. A key distinction here that kind of evolved over BIA case law is what it actually means. The case that I just mentioned was Matter of H, one letter, Matter of H. The big distinction for family-based claims, which is a common confusion, I think, is about how these cases sort of exist, what it means. So it's not enough that there is a family and a bunch of the family members are experiencing some sort of persecution. The crux of this case for a successful and viable family-based PSG is that your client, the petitioner, is being harmed because of their relational status to someone else. As a bit of an example, for example, like if your client is being harmed because they are the son or daughter of their parent who is being harmed as well, like is kind of the end goal of the persecution. So the idea being, and this was very much exemplified in Matter of LEA, a much more recent case that has a lot to say on family-based PSGs. It did affirm that these family groups can constitute viable PSGs, but not on like a blanket scale. They did kind of caveat it that it was dependent on the facts of the case. And most importantly for MRMS, it discussed the nexus requirement for family-based claims and had this language that's on the screen that nexus is not established simply because a particular social group of family members exists and family members experience harm. There has to be something else that ties the harm to the family membership, which we will come back to. The next part that we want to talk about, and for those who were able to join us last month, we did a whole presentation for the Nexus standard for fear-based claims. Under the statute for asylum claims, the Nexus standard is the phrase we're all very familiar with, which is at least one central reason, meaning in this case that the family relationship would be at least one central reason for whatever harm your client experienced. For withholding, there's a little bit of kind of wiggle room there depending on where you're practicing. In the 6th and 9th circuits, they use the lower standard for nexus, which is simply a reason. It doesn't have to be central, just a reason. The BIA, unfortunately, does not recognize that distinction. And so the BIA, the 2nd, 3rd, and 5th circuits just apply the same old standard as for asylum. And then for all the other circuits listed on the screen, it's still an open question. So if you are practicing in those circuits, definitely do check out our presentation from last month for some specific tips and tricks on navigating this issue there. But because the BIA does apply the one central reason standard to both asylum and withholding, that's sort of the language we'll be using here today, since that is what came up most in Matter of MRMS. And next, for a discussion on that, we'll turn it back to Peter.
Before
Thanks,
we jump in,
Amelia.
sorry, we've got one question from Joanna, if you all could address, while we're talking about asylum versus withholding. Is there room to argue that matter of MRMS does not apply for withholding, parentheses, Third Circuit?
Yes, definitely. I think there is definitely room. We will discuss some of what the Third Circuit talked about, and the model briefing that we're circulating also has some great language on that. I do think there's an argument to be made that, especially with, well, in withholding though, they apply the same standard for nexus in the Third Circuit. So you would be making the same arguments for asylum and withholding in the Third Circuit.
Great, thanks. Oh, back over to you, Peter.
Thanks, Adina. So I wanted to talk a little bit about what the board actually did and said in MRMS and some of the reasons why this is such a problematic decision. So first, turning to some of the facts in this case, this was a family in Mexico that had been harmed and threatened and had family members even killed by a cartel. The board did not actually really spend a lot of time discussing the facts in this case, which is odd because Nexus is very fact intensive a lot of the time. There was really only about a paragraph actually talking about what happened to them. But in short, they had several family members who were harmed by this cartel, including the grandson of the lead respondents was murdered. And while there had been a dispute over land, at some point, the respondents made the argument that it had become a larger problem between the cartel and the family, where people in the family were just being targeted based on being members of that family. And therefore, they had their family membership was a nexus to that harm. And the IJ disagreed and denied the claim. So they appealed to the BIA, which agreed that there was no clear error in the IJ's nexus finding. But then the BIA also went on to issue all of this other language about nexus and family-based asylum and withholding cases more generally, and used this kind of as an opportunity to do that. Before I talk about what the BIA did address, I want to just mention that they didn't address a couple of other things here, thankfully, that they could have. LEA was a really harmful decision, as Amelia just discussed, but that decision really discussed a lot of things about cognizability of family-based PSGs. And in this case, the board really only talked about nexus. They didn't disturb any of the really well-established case law saying that families can be PSGs. Most circuits now have published circuit decisions saying that as well. That is not directly addressed or somehow threatened by this decision at all. It was only talking about nexus, and a lot of the language in this case was also dicta. As we know, the IJs and OPLA attorneys can often take what's dicta in a decision and then run with it and present it as kind of the law. And so it can still be harmful, but a lot of the actual comments that the BIA made in this case were not necessarily finding legal tests per se. And so that, I think, does give attorneys more room to argue that some of these things don't apply. So with that being said, let's look at some of what the board did in this case. And as I mentioned, there was a lot of dicta that was really problematic. And there were four kind of main arguments that the BIA made about how IJs perhaps should look at nexus in family-based cases. And the first one was suggesting that to show nexus, non-citizens have to demonstrate that the persecutor was motivated by, quote, overcoming the protected characteristic of the family, or that there was somehow an animus that the persecutor had against the family. And I think that this is somewhat contradictory in terms of how it relates to some of the other things that the BIA said here, because to me, animus against the family seems pretty clear in terms of addressing that as this group had a problem with the family. They harmed members of the family based on whatever that problem was. And if somebody is showing that members of the family were being harmed, I think that that would satisfy that. But the board seemed to be implying in these other prongs that we'll get to that somehow just there being animus might not actually be enough. And one of those things was the board's statement that if there was some other ultimate goal, such as a financial dispute or other extortion, problems with gangs, then family membership was somehow unlikely to be a central reason for the harm in those cases. And the way that the board framed this, where they said it's unlikely to be a central reason, is kind of like in AB and LEA2, the AG decisions where the board or the AG didn't necessarily say this can never happen, but there was this really problematic language saying that most of the time it's not going to satisfy that. And it was similar here in that they didn't completely close the door on these types of claims, but they suggested that most of the time it won't meet that threshold. And that's problematic here because a lot of times there isn't just one reason only, or there might be some original reason why a persecutor went after a family, but it wasn't necessarily the only reason. And they're suggesting that in these situations, that might not be a central reason. Family membership might not be the central reason for harm. Another thing that was kind of problematic was that the board suggested that family membership should be the dominant reason for harm in order to show nexus. And as I mentioned, often there are multiple reasons why persecutors are going after families. The board has already said that dominance is not required, but they have said that the protected ground, like family membership, can't be subordinate to the other reasons, which in practice is really kind of the same thing. Saying, oh, you don't have to show dominance, but you have to show that it's not just subordinate. I think in practice really operates the same way. Finally, the board suggested that while there was not a requirement of double nexus, in other words, that somebody is not just being persecuted or has a fear based on this protected ground of family membership, but also some other reason like religion or political opinion. The board said that's not required, but it's something that will make a nexus finding more likely. And this is something that is also problematic because it's often very difficult to show that necessarily in the same fact pattern, and is just raising the threshold for a lot of people beyond what has been the threshold, the framework in place for a long time. So yeah, these are some of the things that were said that we think are really problematic and set a new threshold for nexus that goes beyond what the INA and the existing case law have required for a long time.
Thank you, Peter. It would be great to hear which of these you find the most problematic and why, so that people can really have an idea of what they're up against in these various standards.
Sure. I think that the second point in particular about if there's an ultimate goal that there can't be, or that it's unlikely to be a central reason for harm, I think this is so nebulous because it really kind of, uses this language that sounds like it's open-ended and not closing the door on that, but also gives the IJ or OPLA attorneys permission to take this and make it sound like there's almost a presumption against that. And there's almost always in practice going to be some other reason why a persecutor maybe is going after a family. Most of the time, it's very difficult to separate these things out in practice. There was one Fourth Circuit decision that said something like, gangs often don't leave, a note listing out all of the discrete reasons why they're going after people. They just, use violence and try to harm people without necessarily explaining everything in these very clear ways. And so I think that this is just a very nebulous point that is going to lead to a lot of denials where people aren't necessarily able to show that there weren't other reasons, or that the family membership was not somehow the ultimate goal.
Thank you. Amelia, is there anything you would want to add to that?
Yeah, no, I agree. I think that out of the four, I mean, I find them all very concerning on a practical level, but I do think that the one that probably touches the most cases is probably the second one. Like Peter said, I think most of the cases, just as a reflection of reality, involve mixed motives, as they're often called, and usually not all protected grounds. It's not just political opinions and family memberships, it's also extortion and gang recruitment and things like that. I also think that this kind of concerns me in relation to a lot of the executive action we've seen recently. I think that with the idea that this could be perceived as a presumption against finding nexus, given other standards that are now being applied at credible fear interviews and reasonable fear interviews at the border, particularly, this concerns me that asylum officers might be applying this sort of pseudo presumption against a finding of nexus if they perceive that there's some sort of ultimate goal in the person's case that is not the family membership. So I think this concerns me not only for the cases that are already like in proceedings, but also kind of forward looking given the general atmosphere we're in right now.
Thank you. If anyone else wants to share thoughts on this problematic language, we're happy to hear. Feel free to come off mute or put thoughts in the chat. I know we have two questions to get to too. Let's go back to. Do you want to do the Fourth Circuit specific question or wait for that one?
Yeah, I'm happy to address that now. I know we're going to talk about circuit stuff,
Yeah.
so maybe I can mention it then.
Okay. Sounds good. And then yeah, we've got two Fourth Circuit questions actually. We have Joanna saying requiring dominant reason is contrary to the statute and is not required for any other PSG. Yeah.
I think that's a great point, and I also think that that is one of the concerns about this case is that it's singling out family-based PSGs in a way that it doesn't for in any other protected ground or other PSGs, weirdly enough. So it seems very targeted at achieving a certain outcome for family-based claims. I think something we were discussing internally was that there was maybe a floodgate concern of, you know, a lot of people filing family-based claims and then trying to kind of close the door, and narrow the gate at least on that. So I agree. I think this is a weird singling out for family-based claims.
And we've got a great question from Jennifer. Can you give an example of what would a clear family membership being central reason? Because like you said, there are mixed motives, so we'd love to see what the ideal one looks like.
Sure, I can take a look at that. And so I think that there's good case law. I mean, we here in the Fourth Circuit are very lucky to have a lot of good case law on that. I think one of the kind of seminal fact patterns that we see quite a bit is gang related. So, for example, where the gang is trying to recruit a certain member of the family, often a male son or young male relative. And then, in order, when that person refuses, or other family members, parents, for example, are expressing the fact that they are not going to let their son join the gang, then the gang starts targeting, for example, mom or dad. And therefore, the mom or dad now has this family based claim. They are not really the ones, they're not being targeted because of themselves. They're being targeted because of their connection to their son, in this case, in the example, because they are being like, that is what drew the gang's attention to them specifically. That's a pretty common fact pattern we see.
Can I ask a question about that? Because like in the fact pattern that you just gave, number two of the problematic language kind of makes me nervous, because if there's an ultimate goal, right? The ultimate goal there would be to recruit that son into the gang, right? So does that now bring that scenario into question for the parents? Because the ultimate goal doesn't come from the parents, right? But the ultimate goal is to get the son to join this gang, right? To force him to join the gang, right? And if that's the ultimate goal, and the ultimate goal is not just to, persecute the parents, would that fact pattern now be not so clear here in the Fourth Circuit?
I mean, I think the Fourth Circuit case law is pretty good on this issue for some of the reasons Amelia just mentioned, but I think that definitely like IJs and OPLA attorneys are going to try to use this decision and say that it somehow undermines uh, those claims, because there often will be other ultimate goals, as you kind of alluded to, Natalie. So yeah, I think it's something that probably will come up, but there is good Fourth Circuit case law in particular. Probably the Fourth Circuit is the best circuit on this question of any, honestly. And so I think people can push back, yeah, but the other family members, yeah, as lawyers, yeah, so it's something that it can be complicated, but often, even if there's some other ultimate goal, or I think it's really kind of a misleading term anyway, because often there's some initial goal or initial reason, and then the ultimate outcome that ends up happening is all of the other family members are being targeted or harmed. Regardless of what the original reason was, there's some kind of eventual situation where everyone is being harmed, regardless of whether they were involved before or not in that particular dynamic.
Thanks, Peter. And I see we have a question from Farida. Am I pronouncing your name correctly?
Yes, that's right. Thank you so much for having this training. I think there's been a lot of questions about matter of our MRMS. I wanted to ask, because I spoke to somebody who recently litigated this issue in a case at the merit stage. And initially when I read it, I got the impression that it seemed to imply that in situations where the primary target of the harm can't establish a nexus themselves, and I don't know if that's just because of the fact pattern in this case, then you can't kind of piggyback off of that, where family members can themselves establish a protected ground through family ties. Is that incorrect? Because she was saying that no, although that's how she had initially read it as well, that those two are not related. So it has no relation to the primary targeting of the principle, I guess. In the case of, even if it was religion or there's a clear political opinion protected ground, that this same issue is going to arise due to MRMS. I'm not sure if my question is clear. Maybe I'm the only one that read it that way.
So I just want to make sure, yeah, maybe I also want to make sure I was clear on that. So is the question that, like, for example, in the family-based case, the issue being that the son would also have to be able to show some sort of protected ground? Is that how you're reading it?
It seemed to come up in the situation where, if in the example that you gave, if the son can't show protected ground, then you can establish like the nexus for the family members, even if they were targeted by virtue of him being targeted. So if DHS would argue, no, this is just generalized criminal activity, or no, this is extortion, then you're not establishing a protected ground by which the family members then derive because of their relationship to the son. But that would almost seem to imply that you would need to litigate the son's protected ground, which also wouldn't make sense if the family member, if he's also not here and not in consolidated proceedings. So I just wanted to pose that in the situation that maybe others had read it the same, and how that interplays with the 4 points that you have listed here when making arguments.
I think that really overlaps with the concerns about double nexus as well, because this is something that is not required, and the board acknowledged that here. But as you kind of mentioned, that's something that in practice, if you're requiring some other protected reason for the son or the original family member that the dispute kind of began around, and it wasn't something like political opinion or religion or something else that's clearly established as a protected ground, then I think in practice that is becoming a double nexus test that people are being asked to meet. So I think that's part of why this is such a slippery slope to embracing that kind of a standard, and is really problematic, because that's not the standard in any circuit of what people have to show.
I know we've got a lot of good questions coming in, so let's start talking about moving forward.
Yeah, so as Peter laid out, and as we've been discussing, there's a lot of very problematic suggestions in here that are arguably not new legal rules that are being applied, but as we've been discussing, it sounds like OPLA is very much taking it to be that and trying to impose these new higher standards for family-based claims and, according to the chat, even non-family-based claims as well. So kind of we wanted to cover some things that you might be able to use going forward in your cases. So a big question that I think comes up in this case is, who does this affect? Who's bound by this decision, particularly in circuits with good case law? This is a big question of what you can kind of draw on after this. So under sort of administrative law principles, immigration judges are bound by this. It was a precedential decision, matter of MRMS, and so they are required to, deal with it. The BIA also is bound by its own precedent, but the agency is required to contend with circuit case law. And so for the fact that the Fourth Circuit, for example, is known to have such positive case law on family-based claims, definitely keep arguing all of that, and we're going to talk about that as well. But even outside of the Fourth Circuit, you should still be relying on your own circuit's case law. This case specifically arose in the 10th Circuit. So there's a lot of focus in the decision on a 10th Circuit case called Oriana Recinos. But the decision was written in quite broad language, except for the First Circuit. The decision actually references at least one case from every circuit. The Third Circuit only gets a little mention in a footnote, but it is technically there. So the board does seem to be implying that they want this case to have really wide reach. But as we're going to explain on the next few slides, there's a lot of really good case law from every circuit, essentially, that you can draw on to show that this is not the end-all be-all in your circuit, even if it is technically binding on the IJ at the merits level.
And to that, and we wanted to talk about some of the case law on these different points from a lot of other circuits. I'm not going to go through all of these decisions because we don't have time necessarily, and I don't know what all of these say in great depth, but as you can see, this is pretty much every circuit has case law on this issue, much of it published. So it's something that has been addressed. And to the extent that, for example, ultimate goals have been reflected in this case law, the Fourth Circuit, which, as I mentioned, is probably the best circuit in the country on nexus and family-based cases. Hernandez-Avalos is kind of a seminal case, and the board actually discussed this case in MRMS. And in that fact pattern, there had been a mother whose son was being targeted for recruitment by the gang, and the mother opposed the gang trying to recruit her son and was very vocal about that, and the gang ended up threatening and going after her as well. And the board tried to say that this was somehow, a problem with the gang based on opposing recruitment and not her family membership. And a fairly conservative judge wrote the panel opinion for this decision, saying that that was a meaningless distinction and that it was arbitrary and capricious for the board to have found that there was somehow any distinction between that reason and family membership in terms of nexus. So not all of these decisions necessarily are that far or represent that clear of a legal rule in each of these circuits, but there is case law from a lot of circuits on this ultimate goals question that I know we've been talking about today. So these cases are kind of a starting point for research and making some of these arguments in your own circuits. And if you are in a circuit that has case law on this, the Fourth or otherwise, that has a clear legal rule, the board and the IJs have to respect that. And there was a Fourth Circuit case last summer, Garcia, that really talked about that if there's binding legal precedent, the board really has to defer to the circuit on what those rules are. And I know there are complications with Brand X and some of these things where there's tension between the agency and the circuit case law, but especially if Chevron is overturned, as I think most of us are kind of expecting in the next few weeks to happen, that will probably put each circuit's own case law in even greater context and make that even more important to look at what those things are without having to defer to cases from the agency that would otherwise undermine that. There's also some case law on another issue regarding dominant motives. So as I talked about before, in cases where the agency tries to say that the family-based membership was not actually the dominant motive or was somehow subordinate to other reasons, there are ways you can push back. Some of these cases are not necessarily family-based, such as Ende Chemie from the Third Circuit. That was a case where the other protected ground actually, or the protected ground that came up in that case was ethnic origin, Burundian nationality. And so the other dispute that had come up was somehow being treated as a dominant motive relative to the protected ground. And while the Third Circuit ultimately denied in that case, they said that the board's definition requiring one motive to be dominant rather than subordinate was somehow not acceptable because it really undermined only needing to show that the protected reason was at least one central reason for harm. You don't have to show that it was dominant, and you don't have to show in the Third Circuit that it also was not subordinate, as long as it was one central, at least one central reason for that harm. And so there's some case law on this question and a few other circuits as well. And even if the board in this case, in matter of MRMS didn't necessarily say that dominance was what it was requiring, I think the subordinate motive language is still problematic for some of the same reasons, and it's something that you should push back on. Finally, on double nexus, as we've talked about, this is something that no circuits actually require for family-based PSGs or for any protected ground. If you can show one protected ground, that should be enough. And so you can cite to some of these cases in talking about that and pushing back on that argument if it seems like something that OPLA is trying, or the IJ is trying to require in your case for nexus. And again, these cases are kind of just a starting base. So yeah, feel free to use these, but there's others out there as well.
So besides the research, which we hope will be helpful for you as you brief and get ready to argue these cases, we want to also talk about some other kind of practical tips. And so as we've been discussing, if there is good case law in your circuit, please be arguing it. As was discussed, I saw in the chat, there was some conversation about preserving arguments and things like that. And so it's wonderful to be bringing up the case law right from the IJ level, preserving it at the BIA, and then if need be, being able to fight about it over at the circuit court level. So be raising all of the good circuit case law that you can find. The second one that I think is really important and can feel like a glimmer of hope, hopefully, after reading this decision, which is kind of a throwdown on Nexus. Nexus is inherently intensely fact-driven. So as Peter mentioned, it's sort of odd that this Nexus case, MRMS, was very sparse on facts, actually. And so that leaves a lot of opportunity for you in your cases to distinguish. Because there were very few facts raised in MRMS, your case can be distinguished on all the facts that you will hopefully be raising and building the record on. So even if you, are at the IJ level and want to argue that MRMS was wrong, but even if it applies, you still should win, this is a great place to build up the record on your facts. A good reminder, as Peter mentioned, is to remind the IJ and OPLA, if they're arguing this, that MRMS did not touch the cognizability of family-based PSGs. That is still exactly where it was before December of last year. And so any attempt to read MRMS as undermining those claims on like a legal cognizability issue should be pushed back on pretty hard. Relatedly, I think it's important to remind OPLA what is and isn't dicta. I think we all know OPLA is not necessarily one for always reading things super closely. And so I think it's important to remind them that this was not a holding. Like a lot of the things we've been talking about, ultimate goals and, it's helpful if you have double nexus, all that, that's all dicta. That is not a holding from the board requiring these showings in order to establish nexus. So it's good to remind them of that. But with the fact that it is sort of out there and it is at least a suggestion, it's important to gather evidence that you have at your disposal, if it's available in your case, to meet the type of things that the board was raising, particularly about animus. If you can show that there was animus against the family, that somehow either was a change in circumstance, kind of like Peter was talking about earlier, or that was overcoming any other goals, that would be really important to preserve and to bring up. For example, something that might be really helpful is if the goal that maybe started the whole persecution was accomplished and then the harm continued. For example, if they were asking for ransom, the persecutors were asking your clients for ransom and were harming them until ransom was paid. Ransom was then paid and then the harm continued. Then I think that that's a great place to show animus against the family, showing, okay, there might have been some other goal originally, but we've moved on from that. Now there is actual animus against the family members for something, actually related to the family. And then also, if it does exist, showing double nexus is great. One protected ground is enough under the statute. 2 or 3 is even better. So if you have them, definitely show them. And I saw this was discussed in the chat, it's good to preserve the argument that this case, matter of MRMS, raises the bar in a way that is contradictory to the language of the statute, of the INA, and then also contradictory to prevailing circuit case law. And so it's important to preserve that. Like we said, the IJ won't be able to do anything about it. The BIA is very unlikely to reverse themselves on this issue, but it's important to preserve it so that when you get to a petition for review, which of course we hope no one does, we hope you're all winning all of your cases, but on the case, in the instance that does come up, you've preserved the issue there. If your circuit allows for it, as I said, based on our last roundtable from May, if it's a possibility, be arguing for a lower nexus standard for withholding claims. If this case is interpreted to be raising the standard for asylum nexus burden, then it's especially important to be leaving the door open for your clients to win withholding on a lower nexus of a reason instead of one central reason. And then finally, I think that one thing that is important here is that if the IJ and OPLA are using this case to really narrow the possibility of accessing asylum for your clients, don't forget other forms of relief. We, of course, understand that asylum is sort of the gold standard. You get the most benefits. You can get your green card. You can naturalize, all that sort of stuff. But it's really important, particularly in this environment, I think, to be remembering other forms of relief like cancellation of removals, U visas, and also we wanted to highlight arguing for protection under the Convention Against Torture, particularly. We have seen cases where the client was denied withholding due to usually a lack of nexus or of some sort of cognizable PSG, but winning on CAT. So it is definitely an option for your clients when they are facing risks of severe harm and torture in their home countries, but maybe the facts aren't really there for nexus, or they are for a reason, but maybe not one central reason. So it's important to be preserving really good CAT arguments as well as other options for relief for your clients. And finally here, just kind of some pointers here. As we mentioned, it's important to preserve all the issues. Your case at a PFR stage could become a case that sets really good precedent for everyone else. And so it's important to be leaving the door open to arguing nexus issues and other things at the circuit court. And we, of course, as Adina mentioned, are always happy to look at cases and referrals. There are other great, wonderful organizations in the country also doing impact work. If we are not working in those circuits yet. So definitely please do reach out for cases. And also something we want to be hearing about now from you is how you're seeing these cases play out. Are you seeing OPLA bring this case up? Clearly someone in the chat who had mentioned that this came up in a BIA decision. You guys are seeing some of it. But have you also been winning any cases because of this? Have you been able to use the language to your advantage? So we'd like to open the floor a bit to kind of hear some of what you guys are experiencing.
In particular, if you shared something in the chat, there were a lot of messages that came in. Make sure to come off mute and highlight it so we can address that. I want to make sure we don't miss anything. Burning questions. Most of them, I think, were addressed by the presentation, but let us know. And I'm seeing Sylvia just shared about a case in the Ninth Circuit. Sylvia, if you're able to come off me and share about that, it'd be great to hear more.
Yeah, I can do that.
Thank you.
This was a case that, let's see, it was heard in October before MRMS was issued. And so we had the final hearing and the IJ set it for a written decision. But like at the hearing, the IJ was like, oh, I think it's a central reason, like, will you take withholding? And my clients were like, no, we want asylum. So then he issued a written decision granting withholding since it was a central reason. But yeah, the family wanted to, I mean, most of my clients, if they get withholding, don't want to appeal, but these clients were like, nope, let's go for asylum or nothing. So they appealed. So it's pending, which is nice because it is a strong, like it says in the facts, like many, many members of the family were harmed over long periods of time, like with kind of different, like immediate fact patterns. So like I think if it was a case to like it seems winnable technically, who knows what new case law will be issued, but yeah, that was my experience.
That sounds like a really strong fact pattern, and yeah, I hope that the appeal is successful. I think there's some good Ninth Circuit case law on this question, so hopefully that'll be something helpful at the BIA level. But yeah, I think this is a really good example of how this idea of what an ultimate goal is kind of something that often does get overblown relative to what the other harm was. And it sounds like really the original and the ultimate reasons for harm were just animus against this family, and the fact that there happened to be some extortion mixed in at one point shouldn't defeat that in thinking about it. So yeah, it sounds like a really strong case, and thank you for sharing that.
Thank you. Let us know how it goes and if it goes up to the 9th. We had a question way in the beginning from John. He mentioned a case in Baltimore and said the persecutor's threat to a mother and son, our clients, was motivated solely by a desire to persuade the father to join the gang. Is our argument for family PSG that MRMS is contrary to Hernandez-Avalos from the Fourth Circuit?
Yeah, I think that as we are going to circulate some model briefing, and that is definitely something we highlighted in our Fourth Circuit model briefing, is that this kind of suggested new heightened framework under MRMS is contrary to the bulk of our very wonderful Fourth Circuit case law on this. And then I think it's worth, and then the model briefing also includes sort of an alternative argument, like saying if you apply it, we should still win because of X, Y, and Z. But I do think that in your case, John, that the best argument is to keep arguing for Hernandez-Avalos and all the other case law that the Fourth Circuit has on family-based claims, because it sounds very analogous to the fact pattern in that case.
Thank you, Amelia. Another fact pattern question about a father who suffered Nepali Maoist extortion in the past, which is now the government in Nepal. And now a splinter group of Maoists are asking for money from his son. Does this establish nexus?
Yeah, I think with those facts, it's definitely something you could establish. I'm curious if there was perhaps some kind of political component to that harm as well. So I know there has been political violence in Nepal in the last couple of decades based on people opposing the Maoist groups or the monarchy that existed. So if there were facts like that, it's probably something that would be helpful to show as well, but I don't think you would need that. And if there was other harm or things that especially somehow superseded just the extortion, I think you definitely have a really strong fact pattern there.
Any other questions coming up? Joanna, I'm wondering if there's any of yours we didn't address you want to raise up, if you are able to go off mute.
Hi, did you say Joanna?
Yes.
Hi, thank you.
Hello.
No, I don't think so, but thank you. This is really wonderful. Um, oh, maybe the brand X type of thing. Like, what if the circuit court law that helps you is earlier in time than the BIA case law? Like, how can people sort out that?
Yeah, I mean, I know in the Fourth Circuit we've been lucky to have this case law for almost 15 years, but it's possible you're in a circuit that has much older case law than that. So I would I think the displacement of Chevron will definitely impact that because Brand X is kind of a child of Chevron deference, right? So I think that once Chevron probably is overturned, then it will be much easier to make those arguments that there shouldn't be deference to the subsequent agency case law. I wanted to just address the question from Sylvia about supplemental briefing. I know I have a case for a man who has won withholding twice now based on a family-based PSG, and the government has appealed both times. The original grant was more than 4 years ago, and it's now been pending before the board for more than 3 years after the government appealed the second grant. I filed the briefing at the BIA almost 2 years ago. And I did file a supplemental brief on this in January after MRMS came out. We're still waiting, so I don't know. I know for some of the non-detained cases in particular, you really can have to wait years and years before you get a decision. So it's likely, that if you've had a family-based case, you may have had to brief it during when it was still LEA, and then that wasn't the framework anymore. And so you might have filed a supplemental brief about that and now have had to address this. But yeah, I would encourage you if you're in a circuit that has good case law on this and are concerned that MRMS could be something that is brought in to address it. And it doesn't have to be something really exhaustive, but just responding to it and either saying MRMS should not apply because of the circuit case law, or if it does, I have the facts in this case to win under the MRMS framework anyway. And we kind of did that in the sample briefing. So I hope it'll give people ideas about how to do that in their cases.
Thank you. To conclude, do either of you have thoughts on why you think the board is going after family-based claims? Why we got this decision after LEA and everything?
I think partly it's because these are such common PSGs that many people really are able to bring and win on these claims. And almost everyone basically belongs to a family, right? And it doesn't mean that all harm is necessarily based on that, but I think it's something that happens in all of these different countries around the world. Many people have this type of harm, and so I think that some of it is a floodgates concern of trying to foreclose on that. And yeah, in terms of the BIA members, One of them was appointed by Bill Barr and the other by Eric Holder. And then there was one who I believe was originally appointed under George W. Bush and then again under the Trump administration. So there's a lot of BIA members. I think there's something like 20 now, including the temporary ones. So when you have these 3-member panels, you can get really bad panels that issue these decisions and aren't necessarily en banc of what the entire BIA would have decided, but did in this case. And so I think, unfortunately, it's an example of that. We do have some better appointments now of some of the BIA members that I think are being a little more thoughtful, but yeah, that's part of the problem here.
Thanks, Peter. We are almost at time, so just a couple logistics. Our next roundtable is not going to be the first Thursday of every month like we usually do due to the July 4th holiday, so it will be July 11th. We'll be digging into criminal immigration matters. I'm curious, do people want to hear about the recent notice for proposed rulemaking that would make certain mandatory criminal bars in the CFI-RFI process? That's something we're doing a comment on right now, so we might be able to talk about that a little bit if folks are interested. Just let me know. And here's other upcoming trainings we have for the year. I just put in the chat, if you do want to join the July training, it is a separate link from the other link. So normally you just register once and you get the whole series, but again, July is a separate link I just put in the chat. And then, as I mentioned, in case you were here in the beginning, we are changing our name for our organization on Monday from Care Coalition to the MICA Center for Immigrant Rights. So going forward, you can reach us and refer cases. We need to update this. It'll be lab@amicacenter.org. I'll put that in the chat too if you want to save it. We always love hearing from you all. And we thank you for taking the time to talk about this issue and share your insights, and especially to Peter and Amelia, who did a fantastic job preparing this and worked very hard on the model briefing that I will email out along with the replay as soon as it's ready. So thank you so much, everyone. Let us know how your cases are going on this issue, and we'll be in touch. Thank you so much.